All right, welcome everyone. Good afternoon. Welcome to our seminar, How Can Law Inspire Hope for an Inclusive Anthropocene? Yeah, that's the title for our seminar today. It is the third public seminar of the Anthropocene Laboratory of the Royal Swedish Academy of Science, which was inaugurated earlier this year. This public seminar is organized in collaboration with Stockholm Environmental Law and Policy Center at Stockholm University. Today's seminar with legal scholars and practitioners on rights of nature, public participatory rights, and human agency illustrates the approach we are taking at the Anthropocene Laboratory, which in the welcoming speech our director will talk to you more about. We're very excited to have you joining us today on site here at the Bayer Hall at the Academy, as well as online, because this public seminar is also streamed online. We are really excited to start our public seminar series with such an incredible lineup of speakers and commentators, which I will be introducing to you one by one later on. We hope it will be a day in which thoughts can be inspired, shared, and nurtured about the role of legal tools to encourage hope in this era of the Anthropocene. For those of you who are not familiar with the term Anthropocene, it is a term commonly used to describe the era in which we are living right now, an era in which humanity has substantial impact on our planet, including its biosphere and climate system. My name is Dianti Ningrum. I'm a postdoc who works on the topic called the empirics of hope here at the Anthropocene Laboratory, and I will be your guide today throughout the program, and I will moderate the panel session later on this afternoon. So just a little bit of structure for today's public seminar. We will have 3 speakers in the first sessions early in the public seminar, and then we will have 15 minutes break, and then after that we will have a panel session preceded by some of the comments from our commentators here today. Some of the words from myself about the public seminar. So why did we decide to have a seminar on this topic, on law in the Anthropocenes, particularly related to inspiring hope? So living in the present and future Anthropocene requires a new relationship between human and the living world, or nature, as some of us call it, and we need to rethink how this relationship throughout society, right? So in the domains of law and governance, there is an increased attention to ecological jurisprudence, which recognizes humans as one part of a wider community of beings on planet Earth, whose well-beings are interconnected with other members of this community. So one of the popular concepts recently adjacent to this school of thought is the rights of nature, which will be one of the key topics that we'll be talking about today, which seeks to promote the rights of non-human life, or the living world. And in the last decade, significant developments have taken place to promote public participation and participatory rights in environmental matters. So civil society, including environmental defenders and stewards, as well as members of the public at large, they're participating in decision-making and judicial processes, and lawmakers and law practitioners as well. They are some of the most notable human agents in law and governance system. So that's kind of like a brief overview of what we're going to be talking about today. So before we dive into the first session of today, I would like to say a few practicalities. For those streaming the session online, unfortunately, you cannot leave comments online. That's only for the people in the room today. But yeah, I think you're welcome to take notes of the people who are giving out talks today, maybe reaching out to them if you have any questions. For those attending in person, foods and drinks are not allowed inside of the hall. There will be a 15-minute break before the panel session. And it is our wish that the sessions run smoothly without interruption, and we would thank the audience if they can turn off their devices during the session. So before we have our first speaker of this afternoon, I would like to invite the director of the Anthropocene Laboratory, Henrik Oosterblom, to say a few welcoming words to you, just very briefly.
Thanks so much, Janti. Welcome, everyone. Thanks for spending the time with us this afternoon and for participating in this seminar. So my name is Henrik. I have the pleasure to be the director of the Anthropocene Laboratory. It's a new program at the Royal Swedish Academy of Sciences. We've been around for about 2 years. And our goal is basically to develop new scientific understanding across academic disciplines related to the big Anthropocene challenges, with specific focus on the biosphere, this thin layer of life that enable us to thrive here. We really want to stimulate conversation across disciplines and engage in practical issues of relevance, and also think about how the laboratory and the network that we are working with can help stimulate agency and advance some of these challenges and look for opportunities together. And of course, we also want to, in this work, stimulate or normalize more of this transdisciplinary scholarship and work with Dianti and other young scholars and help sort of create conditions for academics who are interested in bridging disciplines and bridging between science and practice. So in the lab, we have been basically for 1 year worked with developing 2 different research tracks. One we call the Empirics of Hope, and that's the one that Dianti is leading, and this is basically the second public seminar on this topic. The other one, we call it the Intertwined Biosphere, which is basically an attempt to try to understand some of these intertwined relationships between humans and the rest of the living world. And this is a program that's led by Chelsea up here. So yeah, when it comes to hope, we've been doing a lot of work trying to understand how can you study hope, what disciplines do you need to involve, what are the kind of data that would make you hopeful or not, or what's the information that we can look into to really understand whether or not we are, as a global society, trying to transition into more sustainable behaviors and practice. And I think we found quite early on that the practice of law is one that is quite interesting and relevant when you're looking for hope, because there's a lot of really exciting developments, both when it comes to changes to national constitution, integrating nature, and court cases that really gives legal rights to nature. Lots of court cases, of course, directed towards government and corporations that are not living up to their commitments. So law as a tool for us to live and thrive in the biosphere is something that we're quite excited about. And this is also something that Jonas raised during our inauguration, that we should be focusing perhaps more on law. So we're excited to be able to take a big step in that direction. And with that, I would just, again, welcome you all here today and thank, again, Jonas and Cynthia and Dianti for organizing the seminar, and for our short distance and long distance travelers all the way from across the highway here at University Campus or across the ocean. It's in Oregon you're traveling on this time. So yeah, with that, again, welcome. Thanks everyone for making the time and for participating in this exercise, and really looking forward to interesting presentations and conversations. So back to you.
Thank you, Henrik, for the welcoming speech. So just connecting to what Henrik has said, we think this topic is very important as one of the key where we might find hope in the Anthropocene. So some of the key questions that sort of guide us for our session today are the following. How would the emergence of ecological jurisprudence aid in imagining and achieving a common future in the Anthropocenes? How far does expanded participatory rights will take us? Are there alternative legal concepts and approaches that could lead to the same result? How do we make sense and use our agency, or human agency, in law and governance system? And how do we come together in this common effort for living in the Anthropocenes? So first, we have our first speaker for this public seminar here with us, Craig Kaufman, who will give a talk titled The Eco-Jurisprudence Monitor, Tracking Global Developments in Ecological Law. Just a short introduction for Craig here. Craig is a professor of political science and environmental studies at the University of Oregon. His research and teaching focus on environmental politics, ecological law, rights of nature, and sustainable development. He is the author of numerous articles and 2 books, including The Politics of Rights of Nature, Strategies for Building a More Sustainable Future by MIT Press, out to 2022. And since 2021, Craig has led the Eco-Jurisprudence Monitor Project, an open access interactive online platform that tracks ecological law initiatives globally and provides related information and resources for policymakers, researchers, lawyers, and activists. Craig is also an active member of the United Nations Knowledge Network on Harmony with Nature and a founding member of the Academic Hub of the Global Alliance for the Rights of Nature, or GARN. Craig, the floor is yours.
Thank you. I want to thank Dianti and the other members of the Anthropocene Lab for inviting me to the talk, and also it's been a real privilege to be able to spend the last 3 days brainstorming and talking with them about what we might look for and think about the empirics of hope in the legal realm. So as Dianti said, my comments are going to come out of my work in creating the Eco-Jurisprudence Monitor, which I created with the help of an interdisciplinary and international team of researchers. And as the name implies, the monitor is an effort to track the proliferation of initiatives or attempts around the world to pass or adopt different kinds of legal provisions that are rooted in ecological jurisprudence, which is an emerging contemporary trend in legal thinking and practice that rejects the anthropocentric assumptions that have really dominated traditional legal thought over the last couple of centuries. So this is just a picture of the dashboard, which is kind of the center of the ecological monitor. So the basis of the monitor is a data set of these different initiatives, but we also provide supplementary information as well as a legal toolkit that includes a searchable archives of the original legal documents. And so I invite you at your leisure sometime to check it out at ecojurisprudence.org. So today, what I want to do is just give a sense, kind of an overview of some trends in the development of ecological jurisprudence, as well as then provide some examples, some observations of the different ways that advocates of this new legal paradigm are using to try to embed these new legal principles in different kinds of rule systems at various levels around the world. So first, let me talk a little bit about what I mean by ecological jurisprudence. So when we were trying to think of the criteria that we would use for deciding whether to include a particular initiative in the monitor or not, we drew heavily on a framework of characteristics of ecological law that was developed by Carla Siebert in her 2020 book, The Lens of Ecological Law. And we sort of boil it down to two broad, I guess, criteria. One is that it really has to transcend an anthropocentric view. So what I mean by this is it has to recognize the value of more than human entities. And I think equally important, kind of move away from this sense or this assumption or framework of seeing nature as a set of independent stocks of resources that particularly that can be sort of manipulated and rearranged in ways with the expectation that that's not going to have negative consequences or spin-off effects. And instead, is based on a recognition that we see in ecological law and, of course, traditional ecological knowledge holders that nature is probably better understood as a set of nested systems in which all of the component parts, including humans, but as well as the more than human world, are interdependent and tied together through reciprocal relationships. So we're talking about a transformation in the legal system to be more systems-based and rooted more in a relational ontology. And of course, then this leads naturally to the second criteria, which is the idea that it would prioritize ecological well-being. And I want to emphasize, this isn't to say that it rejects or diminishes in any way the value of human interests or human well-being, but rather is the idea that if we understand humans as being embedded in these natural systems, then a logical conclusion of that is human well-being has to be tied to the well-being of the natural systems that provide the conditions for life, right? So, and then third, to be included in the monitor, we're only including initiatives that are explicitly legal, by which I mean these are attempts to try to change formal rule structures to embed these ideas and these principles within some formal rule structure. So the first point I want to make is that because these initiatives are emerging around the world in different political, legal, and cultural contexts, as you would expect, they're going to be framed, they are being framed and constructed differently in different places, adapting to their climate. And so there's a variety of different kinds of approaches that we can see. And one set of approaches in societies where they indicate what they value by recognizing them as having rights, which is true for some societies like the United States, for example, you see the emergence of rights-based approaches. But I want to emphasize that not all rights of nature legal provisions are structured or constructed the same. You're seeing a fairly wide variety of different approaches based on different kinds of logics. I don't really have time to go into details about that. I can sort of talk more about that in the discussion section, but I'll just note that a lot of the distinction comes down to whether or not you recognize nature as a system that possesses kind of a unique set of rights that are unique or adapted to particular systems. So the right to regenerate its natural cycles, the right to evolve naturally, the right to be restored when damaged beyond a certain level, and so forth and so on, which is distinct from a different approach where you recognize a natural entity as a legal subject, but then recognize it with a specific recognized concept in Western law of legal personhood, which really recognize a set of procedural rights that are treated the same as any other legal person, whether you're a human or a corporation or what have you. So there's a recognized set of, quote, rights and liabilities that are afforded to all legal persons, and then just sort of putting those onto a natural entity. And of course, animal rights developed separately from the rights of nature movement through a different parallel process, and that follows a different logic of rights. One of the reasons why we track these distinctions in the monitor is because there's a growing body of empirical research that suggests that legal personhood for nature can often result in unintended negative consequences, which I could talk more about in the discussion section if you like, which has then led to the emergence of kind of new legal concepts like legal entity or living entity, which are trying to grapple with, try to find some way to recognize a natural entity as a legal subject, because in most Western legal systems, you are either a subject and therefore you can be recognized by courts and other formal institutions, or you are an object in which you have you're not recognized, right? And so these concepts of legal entity or living entity are experiments with developing new kinds of legal concepts where you recognize a natural entity as a legal subject without imposing this concept of personhood modeled and all of the baggage that goes along with personhood. I'll also just sort of note there are many strategies from different kinds of actors. It's important to recognize the contributions of different indigenous groups that are engaged in this discussion. And there's an international network of indigenous groups that recognize, as these discussions are becoming more and more prominent and they're resulting in actual rules changes, are trying to impact this discussion in ways that they would argue, I think, they have an interest in trying to make sure that whatever construction of rights of nature becomes dominant, that it's consistent with indigenous rights and other the paradigms that they value. And so they're putting together this concept of inherent relational rights. And the point there is, the argument that if we're going to think about a right structure, let's at least make sure that any rights of nature are not, that are inherent, right? This is not something that humans are granting to nature, but that these are inherent rights. And also that it should be based on a relational ontology. There are many societies, though, and many groups where a rights-based framing is not particularly salient and so may not be particularly the best strategy for mobilizing public support. And there are other societies that take a responsibilities approach. And so examples of this are ecocide laws, rule systems for enacting this concept of ecological civilization, earth trusteeship, laws recognizing and protecting sacred natural sites. So we can go into those in the discussion if you like as well. I guess the point, one point I'll just note is if you look at clustering of different approaches for ecological jurisprudence, there is some regional clustering, right? So the majority of rights-based approaches do tend to cluster in the Western Hemisphere, which might make sense if you think about which societies are particularly rights-based. Ecocide tends to be more salient or prominent in Europe. Ecological civilization is a concept that's emerging primarily in Asia. and many of the African initiatives are framed around sacred natural sites. And then if you look at the international policy arena, you see the emergence and use of this concept of harmony with nature, which in my opinion seems to be applied as a linking concept for these various kinds of approaches. So just to give you a sense of the growth, there's been a dramatic growth, exponential growth in initiatives. So again, these are attempts, which I think it's useful to just even acknowledge or try to measure these initiatives because it tells you something about the empirics of hope. Like these are groups of people that are mobilizing, spending time, energy, and resources to try to transform legal systems as well as the way people think about human-nature relationship. And they've grown exponentially since really the mid-2000s. And the majority of them have been approved, which also tells you something about I would say, growth in political will to take these ideas seriously. So another kind of metric that you can think about separate from initiatives as a unit of analysis is just like looking at how many countries, the growth in the number of countries where these things are actually being adopted, right? And as of last week, so the stats that I'm showing you are current as of last week from the monitor, there are 38 countries that have adopted some form of ecological legal provision. And of course, the type of legal provision varies greatly, right? Some are in constitutions, there could be statutory law, case law, resolutions, declarations, and so forth. There are another 9 countries where drafts or proposals have been submitted but are still under consideration, where there has not been, at least to our knowledge, yet a decision made. And you can see that a lot of these are in Europe right now. So Europe has been a little bit late to the party, but there's been a flourish in recent years of proposals to change, provide constitutional amendments or parliamentary bills or what have you. And then there are 3 countries that we've been identified as where there's been an initiative, but the only initiatives have so far not been successful. So the first main point I want to talk about is, well, I guess it's really the second main point. So if the first main point is just that you're seeing a wide variety of constructions and approaches rooted in different legal and cultural and political contexts, then kind of along with that, my second point, I wanted to talk a little bit about, provide some examples of different strategies that different kinds of stakeholders or actors are using to try to propel these kinds of transformation that we're talking about in different rule systems. And to me, this is when I think of the empirics of hope, one of the signs of hope is just the creativity and frankly the savviness of advocates to look at their particular political and legal and cultural context and think about where is the opportunity structure where I'm going to have the most leverage. Recognizing that some policy arenas are going to be closed to them and it's going to be harder, but then trying to look for where is the door going to be open. So one strategy is to try to amend the Constitution. I personally think of this as kind of like a high-risk, high-reward approach, right? Like on the one hand, if you can do it, it's great because you get strong enforcement through the Constitution, but it can, constitutions can be difficult to change. That varies, of course, country by country, but in reality, they do tend to be rare compared to some other approaches. Of course, the poster child for this is Ecuador's 2008 Constitution, which recognizes the rights of nature. Many people are aware of that, and there are a number of other, at the subnational level, in countries that have federal structures, you see state constitutions being changed. More often, you see, alliances of just sort of community activists, NGOs might be NGOs of lawyers, but other sort of experts, if you will, allying with legislators to try to change, statutory law, through the conventional legislative process. Just some examples of this would be Benin's 2012 Sacred Forest Law, which recognizes a number of forests as sacred natural sites and then authorizes local communities to use their traditional ecological knowledge, recognizing them as custodians and authorizing them essentially to control governance arrangements according to their traditional governance practices. And another one would be Panama's 2002 Rights of Nature Law. But more interesting to me is the reality is that, this kind of transformation is hard, right? And there's going to be a lot of pushback. And often it can be difficult to push these things through the conventional, traditional legislative process. So one of the things that's been interesting to me is seeing the different strategies that advocates of this approach have used to try to embed these principles in different kinds of rule systems, bypassing legislators that they might think are going to be unduly influenced by lobbying groups that are opposed to these transformations. And this just simply varies according to the legal structures of different countries. So in the United States, we have a ballot initiative as a way for citizens to try to pass laws or ordinances, different rules, bypassing the legislature, right? So you collect enough signatures. It's basically you're appealing to the citizenry and trying to convince a large enough proportion of the population to support this initiative so that you gather the signatures, and if you gather enough, then you can get it on the ballot, and then it goes on to the election, and if it passes, it becomes law. In Spain, you had kind of a similar process through the People's Legislative Initiative, which similarly was an exercise of collecting signatures as a way of forcing the legislature to deal with it. I think my time is coming short, and so I'm going to sort of just go through quickly a couple of different examples. Another strategy is to try to, rather than focusing on laws, go directly to policymakers, such as city councils, and try to convince them to adopt resolutions and ordinances where they're essentially deciding or committing to creating decisions up front based on these principles. And some good examples of this are Santa Monica's Sustainability Code. Another city in Australia called Blue Mountain similarly passed a declaration. Another avenue would be the courts. Like there are some countries that have a pathway of public interest litigation, or in Latin America, tutelas, which are basically creates the opportunity for citizens to appeal directly to the courts if on situations where they can argue the government has been negligent in addressing a problem of public interest. So often these are environmental problems in nature. And so you're seeing a growing group of cases or initiatives in which courts, this public interest litigation is being used, which brings to the table lawsuits, and then courts are unilaterally issuing rulings that recognize these ecological principles, whether it's rights of nature or some other, even in circumstances where you don't have national laws recognizing rights of nature, for example. I'll just sort of end, I guess, with a couple other examples rooted in private law, because I think it's important to recognize private law as well, right? So we're starting to see the emergence of corporations recognizing nature as a subject and then appointing a representative of nature on their boards. So one of the pioneers in this is a company called Faith in Nature, which is a natural hair products company. And then you're also seeing artists trying to work in their space as well. For example, artists that incorporate nature into their work are increasingly recognizing nature as one of the co-producers of the work and a copyright holder that can benefit from royalties, and then those royalties are being used to propel conservation and protection of those natural entities. I assume my time is up at this point, so I will stop there, and thank you very much.
Thank you, Craig. Thank you for a very inspiring talk. And I'm sure we will be spending more time talking about some of what you're intending to talk about later on in the panel session. Next, we have Associate Professor Jaffa Epstein. Jaffa will give her talk titled Rights of Nature, a Fit for Europe. Jaffa is an associate professor at the Department of Law at Uppsala University, visiting researcher at the Swedish Collegium for Advanced Study, and member of the Swedish Young Academy, an interdisciplinary academy for selections of prominent young researchers in Sweden. Her research interest focuses on how scientific knowledge can be translated into legislation and policy, and she has done a lot of work in the space of rights of nature, particularly in Europe. Yafa, the floor is yours.
Thank you. This isn't a prop, I'm just thirsty. But water, you know, rights. Oh no.
That's fine.
Sorry.
You're fine. You're fine.
All right, with that great entrance. Rights of nature laws, as you've heard, have been recognized or enacted in a growing number of jurisdictions around the world. This legal trend has generated a lot of attention in Europe, but so far less action in terms of laws actually being passed and implemented. The Mar Minor personhood law, which Craig just mentioned, which created legal personhood and legal rights for the Mar Minor lagoon and its basin, passed at the end of 2022, was a first and so far only national law to recognize rights of nature in Europe. Rights of nature laws have so far been most successful in countries where advocacy for indigenous rights has coincided with environmental activism. It's sometimes questioned whether rights of nature could work in Europe, or if, on the other hand, considering nature to be a legal subject, a legal person, a rights holder, is simply too different for the European worldview or for European law. Even some advocates of rights for nature in European countries argue that enacting these laws would require a paradigm shift in current views of the relationship between humans and nature. And I think this is wrong. I think that most Europeans already support legal rights for nature. I think the European worldview currently supports treating nature as a rights holder. I think rights of nature are completely compatible with European legal systems. And in fact, I think that the environmental laws that we have today currently recognize rights for nature in all but name. So this talk draws on a few papers, mostly on a forthcoming chapter in Rick Sponken's Jubileum's yearbook, which will be out this April at the Stockholm Culture Night. So in this presentation and in that paper, I respond to several ideas that I think are out there about why rights of nature isn't a fit for Europe. And the first of these ideas is that, all right, I can get the screen too. The first of these ideas are that people don't like it. People fear limitations on the use of natural resources. They fear it will threaten their own rights. Trees will have more rights than people. I hear people, say things like that. Now, EU countries and the EU itself are all representative democracies. If people in Europe don't like rights of nature, that could be a good reason that we don't have them. But the problem with this idea is that far more people in Sweden and in the EU are actually in favor of rights of nature laws than oppose them. In a recent survey study that I did together with colleagues, we used a well-regarded research and polling firm Qualtrics to ask 11,000 people across the EU, would you support or oppose a policy that would give legal rights to forests or rivers, such as the right to exist free from destruction or pollution? In Sweden, about 49% of respondents said that they would support or strongly support these legal rights. Only 11% opposed or were strongly opposed, and a lot were unsure or neutral. But this is a ratio of support to opposition of 5 to 1. In the EU as a whole, support was even higher, with about 62% supporting or strongly supporting, and only about 10% opposed. We broke down our statistics by age, gender, urban-rural identification, And although there were some differences across these categories, in every demographic, in every country, support for rights of nature was much higher than opposition. And 2 other recently published studies corroborate these results. So a Swedish study that asked asked about rights for ecosystems and animals found that a very clear majority found this to be at least rather desirable, even though, as the survey question itself pointed out, this would lead to a limitation on the use of natural resources. An international survey of G20 countries and a few other countries that had good economies found 60% support overall for rights of nature laws. In Sweden, there was about 47% support, pretty similar to what we found in our study. And again, most of the people who didn't support weren't opposed, but rather didn't know enough about, or were neutral, or said they needed more information to make it form an opinion. So together, I think that these surveys show a consistent and true support for rights of nature laws. And I think then that lack of rights of nature laws perhaps indicates a failure of the democratic process. So why haven't these laws been enacted here yet? Well, interview studies do show that at least representatives of extractive industries tend to oppose rights of nature. So the lack of rights of nature laws could represent the over-influence of business interests. Maybe to some extent it's merely path dependency. We've done laws this way before. Maybe we need a bigger push to change direction. Maybe it's just the catch-up effect and the seemingly slow adoption of rights of nature laws in Europe is merely a precursor to a wider embrace of these laws that have been taking shape over the past decade. A second objection to rights of nature is that considering non-human nature to be a rights holder is too different from our current worldview of considering people and human society to be separate from nature, in opposition to nature. The most prominent early examples of successful rights of nature laws were in New Zealand and Ecuador, where indigenous communities were indeed important to the enactment of these laws. Some scholars have claimed that the reason for the success of the laws in these countries is because that the surrounding communities do not view humans as separate from nature. According to this line of argumentation, nature can't be elevated to rights holder in an enlightened society, which views humans as separate from nature. However, this characterization of current thinking, I think it ignores most of how us in Europe actually view the relationship between humans and nature. In secular schools, children are taught that humans are a type of animal, that humans are related to other animals, and that humans are part of ecosystems. They're taught that human communities and lives are dependent on clean air and clean water. They're taught that human impacts on other animals, ecosystems, and the atmosphere will devastate human existence. In short, current mainstream secular European thought, in my opinion, clearly recognizes that humans are part of nature, are dependent on nature, and have duties to humans and other aspects of nature. Okay, so I think it's clear most Europeans consider themselves to have a relationship with nature. It's clear most Europeans support legal rights for nature, which means that the preconditions exist for rights of nature to be democratically enacted. But the last objection that I want to talk about is that even if most people don't consider people to really be separate from nature, the legal system does. Since ancient Rome and the Roman law that modern European law is grounded in, law has categorized some entities as persons and some as things. And it's simply not a part of our legal tradition for things to be people or people to be things. This has never been true. I think companies that are legal persons are basically persons and things. In ancient Rome, sadly, some people were slaves, and then the legal regulation happened both in the part of the law that governed persons and the part of the law that governed things. So I don't really think there is this barrier in the legal system to considering ecosystems or other natural entities to be legal people, even if we kind of teach that this barrier exists in law now, or the separation. But what I hope to convince you now is that although rights of nature have thus far had little success in being explicitly recognized in the European Union or European countries more broadly, nature already has legal rights in Sweden and in the EU by virtue of the legal obligations owed to it under existing environmental law. So what do I mean when I say nature has rights under EU law? I mean exactly the same thing as I mean when I say I have rights under EU law. So, for example, if I would buy an airline ticket and I would not be able to take my flight, I have a right to compensation of 400 euro or whatever, because the airline compensation regulation says passengers shall receive compensation of 400 euro in these circumstances. Now, do we call this a right in the law? Yeah, it says it right there. Right to compensation. But what would you think if the law didn't mention rights? What if it said, just as the law says in its operative part, that if I buy an airline ticket and I'm denied boarding, that I will receive 400 euro? Would I still have a right to compensation? Of course I would, right? That's what it means to have a right to something, that the law says somebody has to give you something. Whether we call that a right or not, it's a legal right. So this argument obviously is built on a Hofeldian view of rights. 3 minutes, I see the sign. Okay, so that's this very mainstream legal idea that we can understand or identify rights, in part looking at the obligations or disentitlements held by others. Hofeld argued in his famous 1913 article, "Some fundamental legal conceptions as applied in judicial reasoning," which I think resonates as clearly today as it did 100 years ago, that we call legal rights, actually describe several different types of entitlements that could be understood by looking at the related disentitlements. So I will kind of skip over this because I'm almost out of time. But so essentially, we understand that we have a legal right if there's a legal duty held by someone else. And I think this is kind of what it means to have a right in Europe, in the legal system, or in the EU. According to the very well-known 1963 Van Gundel-Lewis case, the EU treaties confer rights on individuals when they impose clear, precise, and unconditional obligations on the member states and others. This so-called doctrine of direct effect has been developed over the years, and various aspects are still contested. But I think this is a fair description of what it means to have a right in EU law that can be relied on in national courts. If an EU law includes obligations towards individuals that are clearly defined, for example, a law saying passengers shall receive 400 euro in compensation if denied boarding, means that individual passengers have a right to this compensation and they can go to court to claim it. So it's not controversial that laws that protect the interests of people give rise to rights for people. And of course, my argument here is that when we can find evidence in EU law or in national law that there's an intention to protect a natural non-human entity for its own sake, and there are clear, precise, and unconditional obligations for states and others to do so, it should be uncontroversial to refer to rights for these natural entities. And we can see that there is an intention in various parts of EU law to protect animals or nature for their own sake. The clearest example is animals in Article 13 of the Treaty on the Functioning of the European Union that says, when legislating, member states are going to pay full regard to the welfare requirements of animals because they're sentient, feeling beings. I think this is clearly an intention to protect animals for their sake. And we can also find implied regard for nature in laws like the Habitats Directive, which implements the international laws that recognize the intrinsic value of biological diversity and species and imposes quite strict limitations on harming certain species and habitats. I'll skip to my conclusion. I thought I had 20 minutes, but it turned out we had 15. So sorry about that. But so to wrap up, even if you agree with me that protected nature has legislative rights in the EU, where the law creates clear and precise obligations towards it, and you agree that the court has weighed these rights appropriately against human or company rights and interests, you might still be wondering, so what? If an ecosystem's right not to be destroyed is equivalent to our duty not to destroy it, what does it add to call that a right? And I have 3 answers to this. First, as I would have explained if I had more time, I think that these duties towards the environment are currently have the role of rights and are treated as rights when weighed against other rights and interests in the legal system. And therefore, I think it's actually just more accurate and honest to call it a right. Second, by showing that rights of nature laws are not necessarily substantively different from existing environmental laws, I think they can seem less weird and more relatable. That rights laws don't have to be radical, although they can be in another form. And lastly, from an environmental advocacy perspective, to point out that legal obligations can be reframed as rights may seem facile, but language matters. To quote from Christopher Stone's famous "Should trees have standing?" Judges who could unabashedly refer to the legal rights of the environment would be encouraged to develop a viable body of law, in part simply through the availability and force of the expression. When we talk about our obligations to natural entities as rights held by these entities, we implicitly are acknowledging the implicit value of these entities. They're protected because they have value in themselves. And when we talk about rights of natural entities in laws or litigation, we're giving courts and other legal actors the possibility to do the same. The reasoning is to an extent circular, but the legal process is iterative. It builds on itself. And so I argue introducing rights into legal discourse has the potential to lead to improved protection for non-humans. Thank you.
Thank you, Jaffa. Very interesting talk here. Next up, we have Jonas, who will be talking us to quite a different place than our first 2 speakers here. I'm looking forward for the different perspective of his talk. So Jonas here is the director of Stockholm Environmental Law and Policy Center here at the Stockholm University and the former dean of the Faculty of Law from 2012 to 2017. He established the master program in environmental law at Stockholm University, focusing on the transboundary dimensions of environmental law, access to justice and human rights in environmental matters, and on law and social ecological resilience. He was also for 10 years the chair of the International Independent Review Body, the Compliance Committee of the UNECE, Conventions on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters, or we call it the Aarhus Convention, and he has also experience in environmental litigation. So his talk today would be titled Rights of Nature in the Anthropocene's Prospect, Relevance, and Alternatives. The floor is yours, Jonas.
Thank you very much, and I should start by thanking my colleagues who took this initiative and show my appreciation that they came to me to suggest this idea about organizing a seminar about law and the Anthropocene. And I'm glad that we could do so, and also to invite competent speakers that we have heard to challenge our thinking. And I hope we will have a good discussion with the audience, the participants later on also. For sure, we face huge challenges, as we say when we mean difficulties, in ensuring sustainable development and adequate protection of social ecological systems, environments, nature, biodiversity, and human rights in the future. And it's both important and highly relevant to reflect on the role of law and possible legal avenues to achieve that. When I teach law students, I try to point out to them how much we are tainted by legal thinking and legal concepts and metaphors. For law students, I have tried to test with them about the idea about rights of animals, for instance, and they are quite unattracted to that idea. And I will come back to why I also think that rights to nature is a bit problematic. But when I test it on students, they will say, well, we don't know what they think. If we give them rights, how will we know how to accept? And I argued with them, well, we have that for humans, babies and mentally old people who are mentally retarded or not mentally aware still have rights, and we know usually what is better or what is worse for that person. And then quite often it ends up with the student that say, well, but they are not persons, so they cannot have rights. But the same students, they're perfectly fine in giving human features to big oil companies or to companies in general, because we speak of them as legal persons. And we quite often refer to companies and how they act in terms like being negligent. We give them human features, and students do not reflect on that very much. Of course, it is legally possible to go ahead and to grant rights to non-human entities. And as we have heard, there is an increasing attention to and trust in the idea of granting rights to nature, whether it's referred to as earth jurisprudence or ecological jurisprudence. And the key idea is that granting rights to nature would be an important recognition of these rights as such, and also that it would add to the protection of these rights. I had prepared in my presentation here to say that I'm not as convinced as the previous speakers, but I think when I listen to them, that is more about a nuanced discussion of what we mean. It is what do we mean by giving rights to nature and whether it improves the protection of the environment as such. I think that the trust in what can be achieved by providing rights to nature compared to other approaches is somewhat exaggerated. This is not to say that I'm against it. I have no strong views for or against. I know of cases where, in jurisprudence, it has had a positive impact. And I also support the idea of being the concern of a too anthropocentric approach in law and in human thinking more generally. But there are alternative approaches that I think are also very adequate, and that's what I would like to address. Now, as we have heard, it is a conceptual idea, and I was intrigued when Jaffa referred to Hoffelt, an author whose writing I used a lot, not least in my PhD, which was very long ago. And I think that it's very useful for analytical purposes on what we mean by rights. But before I expand on the more practical legal aspects, I should say that I also think that while I'm not convinced that rights to nature as such is more effective than other approaches, I think the discourse on the rights to nature can have a positive effect, again, as a reminder, and I think this is what we have heard in the previous presentations, of the profound value of nature, and by highlighting the responsibility of humans in relation to nature, ecosystems, non-human species, and also to future generations. And for sure, humans have both moral and legal obligations in relation to the environment, nature, and biodiversity. And again, it becomes a Hofeltian or conceptual discussion whether that as such implies rights for nature. So the issue is not what nature and biodiversity, whether it should be protected, but rather how and what is most effective. And I'm not ruling out that in some jurisdictions, rights to nature can help protecting nature and biodiversity. My key point is that granting rights to nature is not a panacea, is not a cure-all to improve the protection of nature in all jurisdictions. I will make a few examples to illustrate my case. For those of you who have been engaged in this, these are probably quite familiar. Why it may not by itself lead to improved protection, and again, what else could be done. So, we must keep in mind that not granting rights to nature does not imply that nature is not protected. In all cases when rights are granted to nature, and also when it comes with an idea of personhood, the individual specimen or the piece of nature, the land or whatever that we have in mind, has to be represented by someone. So who represents, who speaks on behalf, who acts on behalf of these entities? Is the public authority, an NGO, a trust, an individual, or anyone who wants to do so? It is very much also a conceptual idea. I think the presentation by Jaffa shows that we can indeed construe the situation today of animals as having a kind of right. We have legislation against cruel treatment, against killing of certain animals. In a way, you can say that implies a right, and there are also certain institutions that may act to support that right. The prosecutor should prosecute a person who treats an animal in an illegal way. So you could argue, if you want, that that is a right. But again, we need to keep in mind what we are speaking about. Is that what we want to achieve, or is it something further? Do we think of a piece of land, an area, a river, a mountain, or a forest as an area with a specific personhood that has a right? If this is the case, it will have to be reflected in the law. And if a river is granted a right, then a right to what? A right to exist, a right to be untouched, to have the interest considered in decision-making, and if so, who decides the position of that river in a specific decision-maker? Assume that there is a process to build a highway across that, or to adopt fishery regulations. What does it mean that the lake or the river has a right in that case? In other contexts, having a right does not mean that the right is absolute and trump all other aspects. It is clear, for instance, in the jurisprudence of the European Court of Human Rights, that the rights of individuals to respect private and family life, or to life as such, involves balances of interests. So again, who will act on behalf of that river or piece of land, and who will argue on issues of how to balance the concerns for that area of nature in relation to other interests, other actors? And what is the difference between the situation that the river has a right and the situation, which is a common approach in many states, as we heard, that the river is granted legal protection as a public interest that can and should be invoked by public authorities, supervisory environmental authorities, and possibly also by members of the public, including NGOs, in decision-making and in legal procedures. But again, the concern is if the river has a right, someone has to represent it and explain that. And there we can face problems in terms of legitimacy, democratic rights, etc. We know of the cases that were mentioned, the constitution in Ecuador. There is jurisprudence, not least in Latin America, but also in other parts of the world. But I have not seen any empirical data to show that the granting of rights to nature as such is more effective for the protection of nature than defining the protection as a public interest that public authorities must ensure and act to protect, and that members of the public should also be able to invoke and claim. So in this short introduction, I just want to highlight also that there are alternative approaches to this that has not only gained much attention, but indeed been confirmed in legal developments in the last 30 years. And that is maybe reflected a bit in the introduction that was given to me, and I'm maybe biased in that respect. And that has to do with expanding participatory rights to the public, to members of the public. After 1992 and the Rio Conference on Environment and Development, international law has expanded participatory rights for members of the public significantly. There was no such issue in international law in the 1970s. It would have been impossible. But things changed in the 1990s, and matters that had previously been seen as national became internationalized. So after the Rio Conference, and at the Rio Conference, when states agreed that members of the public should not only have access to information, but should be able to participate in decision-making on the environment and have access to remedies and redress on environmental matters. There was a development of international law. And one of those was in Europe, in the United Nations Economic Commission, where member states in Europe, and also at that time in the newly independent states that were formerly part of the Soviet Union, to negotiate a convention on participatory rights, known as the Aarhus Convention, as was mentioned here. This means that members of the public have access to information and the possibility to view their concerns. They should be able to be part of a decision-making about a road that may have an impact on a protected river, for instance. They should be able to express not only their concerns for themselves, the private interest that their own piece of land may be affected, but if the law gives certain protection to this river, members of the public, in addition to public authorities, should be able to express their concerns in the decision-making process. And if they think that in the final decision about constructing the road, the river was not duly protected, they should also be able to go to court or have a judicial or administrative review of that case. In relation to that, it's also important to point out, as was mentioned in the introduction to this seminar, that as part of the expanded participatory rights, there is an increasing concern about protecting the environmental defenders, which is a very serious issue, essentially, not least in the same countries that have the strongest legal clauses on rights to nature, namely in Latin America, in the Philippines and elsewhere. It's not that I see any specific connections, it only came to mind that actually in the very same countries, Colombia, Ecuador, Brazil, Mexico, Honduras top this list next to the Philippines. So, but there has been interesting development also elsewhere, not only in Europe. In 2003, the revised African Convention on the Protection of Nature include both provisions on participatory rights for members of the public to the same end. And 6 years ago, in 2018, the Escazú Agreement, applicable to Latin America and the Caribbean, set out essentially similar participatory rights as the Aarhus Convention to protect and to make it possible to be part of decision-making and to improve the protection of nature and the environment as such. So the idea is clearly to define protection of nature. We had cases even before the Compliance Committee of the Aarhus Convention where members of the public complained to the committee that under the law of that country, they were only able to address concerns related to the private interest, but they wanted also to view their concerns concerning the public interest. And the Compliance Committee held that the state had to allow members of the public to raise also issues of public concern and to bring such cases to court. So the idea is the protection of nature as a combination is protected in the law and is combined with broad public participation and access to justice. Thus, individuals and NGOs, in parallel to public authorities, can invoke the protection of nature before courts, authorities, and of course in relation to corporations. This can be achieved without granting rights or personhood to nature, and by rather perceiving the protected areas, species, etc., as public environmental interest that anyone can invoke and claim. So, so this is my point. And again, just to conclude, the issue is not the ambition in protecting and respecting nature and biodiversity. It's also not an issue about anthropocentricity only or not. It is rather about what is the most adequate way of doing so. And I hope that we can have further discussions about that when we have our panel in a little while. But I think I stop there. Thank you very much.
Thank you. I will have to ask you to stay there. Also, can I invite Craig and Yafa as well to perhaps we can stand over there, and then we have just before our short break. I will invite each of you to have perhaps just very shortly a couple of minutes to 3 minutes to just have a little bit of a tease before we go to our the panel discussion later on to have a response to each other's presentations. Anyone can first.
I'll start. There's so many things. I could go on for easily hours, so I'm just going to try one each. So, Yafa, So when you were talking, it occurred to me when you were just making this argument that essentially rights can be inferred from obligations or responsibilities, that I think the Colombia's Supreme Court agrees with you, because that's essentially what they did in the Atrato River ruling, right? So I described one of these pathways where citizens are essentially appealing to the courts, even when when they think the legislative avenue is blocked through using tutelas or public interest litigation. And the Atrato River Rights Agreement essentially was judges looking at existing law and responsibilities and making the argument that from this we can infer rights and therefore we must recognize these. And the Inter-American Court of Human Rights did something similar essentially when they said the existence of human environmental rights implies rights of nature, because what good is it essentially to recognize humans' right to water if we don't recognize the watershed's right to keep producing the water? With Jonas, so many things I would love to discuss. I agree that rights of nature is not a panacea, right? And I think I've grown. My personal opinion is you try to pick the framing and construction that's going to be most successful. So as a political scientist and not a lawyer, I'm interested in practical matters of how you mobilize political support and get the job done, right? So you pick the strategy that's going to work in your particular context. But I will sort of note one example of where rights of nature did achieve something that was unachievable under sort of a traditional protective framework. And of course, it comes through Ecuador. Ecuador is a unique example. You can do this in Ecuador because it's in the Constitution, but it just sort of illustrates one point, right? So because the jurisprudence had developed over years, you got to a point where mining concessions were annulled in environments. So what happened was the evolution of rights of nature jurisprudence led to rulings that said, even though a mining company, for example, it's legal for the mining company to engage in this because they met all of the procedural requirements. They got the environmental impact assessment, they met with the ministry and got the license. They managed all the hoops of the normal protection that you would have. The court said that doesn't absolve you of needing to meet the rights of nature. And what it essentially did is it moved away from a system of procedural compliance, checking your boxes, which is, I think a lot of people understand, is some of the problem with the weakness of sort of traditional protective systems, to saying you have to also show substantive compliance. You still have to show that you're not going to disrupt the tolerance levels of ecosystem functioning. So it's just sort of one example of, so Ecuadorian lawyers I know basically made the argument, who have been working on this for decades, have basically made the argument this would have never been possible without the sort of rights of nature framework. But
Thanks.
Thank you. That's a good point, so that I could be looking at what the Latin American courts have been doing for comparison with, explicit comparison with how nature, which is not a rights holder, but is kind of treated like a rights holder in some European courts. I also will choose one comment to each. And so my comment to you is on you make this division between rights-based and obligation-based laws, which is fair. But I do have trouble thinking of like ecocide as not being a rights type of law, and that it's, okay, we're saying we can't do violence to the earth, but as a lawyer, I'm very much stuck in the Hofeldian frame, and it's hard not to see that as a right not to be harmed. Let's see over here. I agree with a lot of what you say, and that I agree that, laws are words, laws are tools, and there are a lot of different, laws don't do anything, but people have to do something with the law. And what's really, I guess, important in any type of environmental protection law is this law actually going to get people to stop damaging the environment, or can it be, and there we go, personifying law again, but are people going to be able to use this law as a tool to stop other people from damaging the environment? And that there are different ways to achieve that. I think maybe there are something within the rights of nature framing that can sort of help clarify what our obligations are, though, if we're thinking about to what do we owe this obligation.
Well, first, of course, it's fair that Craig and Jaffa can respond. I was speaking last, so I could, of course, refer to what you said. But just two short points. I think what our discussion shows that it is also an important conceptual discussion. I mean, for me, my main concern is when you link the right to this personhood, that you must then decide who represents that.
Yeah.
If you have protected interest set out in the law, and if anyone can and should refer to that, but if you construe that as a right, this is not so problematic for me. You can do that again, Hofeldtian ideas. That would be fine. But if you go further than that and argue on its personhood, I don't see. Well, first, I don't think that, generally speaking, that there is so much added value. In certain jurisprudence, yes, but not in all. And then, of course, again, who can speak on behalf of that? The point you made about the Ecuadorian case, I think if you look at what the Aarhus Convention would say is that it must be possible to challenge a decision both on procedural and substantive grounds. So you could essentially achieve that, of course. But I see, it's fine. I'm sure that in Ecuador, this was the decisive aspect of it. So I think this discussion as such is useful. It's just that I think that there is a bit in some community, a bit of almost like an over romanticism that, well, if we only give it rights, then everything is resolved, and that is a little bit what I reacted against. And again, I haven't seen that this approach as such has resulted in more effective protection than in setting out very explicit protection in the law and granting rights to others to invoke and protect it.
Thank you. We're on the dot. Thanks for giving each other your comments, and I'm sure there will be a lot to unpack later on. Now I will invite all of you to have a couple of minutes break until 3:30. So you have about 15 minutes before we will continue to invite, in the second session, to invite our commentators. Here we have 4 great commentators with us today, and then we will proceed to have a panel discussions for our speakers to respond to these comments. You're welcome to spend time here in the hall, but also maybe if you want to have a toilet break, you're also welcome to do so just on the right side of the there. I'll see you in 15 minutes. Thank you. Thank you and welcome back. Now we will be having the second sessions of the afternoon. With us here, we have 4 amazing commentators with us. First, we have Pella Thiel, as an expert for the United Nations Harmony for Nature. Pella has a strong foundation in international networks. She is the founder of An Ecocide Sweden, and in 2019 was named Environmental Hero of the Year in the Biodiversity category by the Worldwide Fund for Nature. And last year, Pella was also awarded the Martin Luther King Prize 2022 for, I quote, tireless work for creation and the conditions for life on our planet. So Pella, you have around 6, 7, 8 minutes for your comments.
Thank you. Oh, it says Brita first, and she says she's going to be critical. So I wanted to go after her.
But I will. So
Good. Cynthia, will you help me with minutes? I don't know what this one is doing. Will you help me with time?
yes.
Thank you. So thank you. It's great to be here, and thank you for hosting this important event on this important topic that I obviously care a lot about. I think last time I was here was in spring when Ron Milo was here, and he said that, you know, there is more plastic in the world than there are animals. Last week, the Living Planet report was issued saying that in my lifetime, we've lost 73% of the populations of wild animals, wild vertebrates. And I think that this is not a coincidence. Like this ecological crisis is not a coincidence, but it's the result of a worldview of separation and domination. And I can give you so many examples of that, but I wanted to give you two. One is when I was in a conversation with the cultural editor of one of the big newspapers in Sweden, and this is a man who he cares a lot about climate change and biodiversity. And he said that actually, you know, if there was not humans in the world who could make meaning and have consciousness, the earth would just be a sphere of rocks and gravel floating in a cold and empty universe. I was so happy to get this view into his mind. So if there wasn't humans, there would be basically nothing. And the other example I have is from last week when I was lecturing in Uppsala University on rights of nature, when one of the students said, well, but how about, you know, most development projects are destructive to nature. And I was so struck by that saying, I had to write it down. Most development projects are destructive to nature. How can we have such a view of development? That's insane. And this is the shift that we have to do now. That's the paradigm shift. Jaffa, you said that enacting these laws would require a paradigm shift, and you were not really sure that this would be the case. I think, yes, that's the case, and it has to be the case. And to me, this is a cultural issue more than a legal issue. So to me, rights of nature are it's not just a legal tool, but it's actually a more accurate understanding of the world, where we understand ourselves as part of a living whole with other peoples, other subjects out there, some of which are human, but most which are not. And that's actually one of the pioneers in the rights of nature movement, or the rights of nature thinking, was a cultural historian named Thomas Berry. And he said, well, we have human law, but human law has to align with the great law, the law that has created us and our society and all the other beings that are out there. It's the ecological law, you know, the law of life. And if we don't align, then we will become destructive and we will not be here for very long. And so in his understanding, actually, the shift that we are in now is not that we are moving from the Holocene into the Anthropocene, because the changes that we are seeing is on a much, much longer time scale. So we are really moving into a new, I forget which is an era and which is an epoch, but I think we are moving into a new era, the eco-stoic era, hopefully. So that's kind of that's the dimension we are talking about. We're not talking about how we structure environmental law to protect nature better. We are talking about the cultural shift, where it's not so much about protecting nature as to respect the other living beings that are here. And so how can law inspire hope for a more inclusive Anthropocene? Well, by addressing those fundamental misunderstandings of who we are as people. And I think, you know, I'm an ecologist, I'm not a lawyer, even if Jonas was my teacher once. Law has been called the DNA of society. So it's a very powerful way of getting a new worldview, because it impacts so much other about how we do our things, what we think, what we strive for, what we mean when we say development, how it is to be a human being in this world. And maybe that's about it. So I think it's, you know, the way we treat our relationship now between humans and the living world is sort of very lame. I think it's below our dignity as humans. So to have a cultural understanding that everyone has the right to life and existence and development is a way also to find ourselves as humans in the world. Yes, thank you.
Thank you, Pille. Next, we have Brita Buckman as our second commentator. So Brita is a senior lecturer in environmental law at Department of Law here at the Stockholm University. Her research is mainly within international and EU environmental law, and it deals with questions related to the role of law in governance of complex environmental problems and legal design. And her research also concerns ocean governance and Baltic Sea environmental law, as well as the earth system governance and earth system law. Rita, the floor is yours.
Thank you. Wow, so many things to comment on, and I must start by making Pelle a bit disappointed because I'm not that skeptical. I agree with a lot of what you say, and I especially agree with the fact that we need a paradigm shift and that this is not maybe a question of law, but a question of values. I was a bit agnostic, or I am a bit agnostic though, about the rights of nature and agree a lot with what Jonas said about finding other ways where law can, for example, through participation, create the same kind of pathways to success with stricter protection laws and sort of finding these persons or organizations and actors that need to represent the rights of nature in whatever way nature is sort of represented in the legal process. And Jaffa effectively also answered a lot of the questions that I've had about how to look at rights of nature. Because the way I see it as a more traditional legal scholar, dealing with environmental law, but also with resilience law and the human nature relationships at large, and not least earth system law, I find that a lot of the solutions are really already in the legal system as it is and within the legal tools and designs that we have. But that the problem is mainly three, and I don't know if that's sort of a comment, but first of all, law is value-based. So that's why law is not effectively doing what we want law to do when it comes to the impacts on nature and environment. Because we have protection laws, but they're not implemented sufficiently, or they're not sufficiently sharp. The second thing is that whenever a decision or a law is implemented, there are trade-offs to be made, right? So whether it's the rights of nature or a protection of nature, there is also other interests, other rights that need to be taken into account, which also makes sort of the nature protection not being sufficiently taken into account. And perhaps that would also be changed if we had the values that sort of corresponds to the rights of nature. Meaning that I don't think we necessarily need to have it stated in the legal system that there are rights to nature, but that the values that rights of nature builds on would create better force in enforcing those laws. And then last, there may also be sort of conflicting interests on different scales of nature protection. So, well, maybe saying then against what Pelle said, but when we need infrastructure for working towards, not towards, but against climate change, for example, renewable energy, then there will be a global target that will be in conflict with the local target of protection, the rights of nature, or protecting nature. So where is that sort of trade-offs also between scales and where do we land in that? And so when I listen to all that's been said, and it's very interesting to see that this is a change and that there are working in some legal systems. I don't see that this is the solution for everything. I see that the shift that would be necessary in order to really have a legal system that represents rights of nature, at least in Europe, on the European perspective, would also perhaps make the legal system that we have and the legal tools more effective in themselves. And going from that and the balancing of interest and the role of law, I think I was lecturing in Uppsala also last week and talked to a girl from Romania who said, well, all of this that you're talking about the law for environmental governance, it's not possible in my country because people have no education and they have no information. So not only the right for participation, but also the right for information that we have through the Aarhus Convention is such essential for any kind of enforcement of protection laws. And secondly, I've been dealing a lot with a concept called Earth System Law. So I would also try to sort of shape or change the perspective towards that, not only focusing on the rights of nature and the protection of nature, because I also think that in the larger perspective of this Earth System Law, we also need to look at other areas of law and see sort of where are the baselines in other legal areas, what is allowed in other legal areas that, for example, when we talk about development, would need necessarily to mean that we will harm the environment, where in other legal areas do we also need to change in order to create this value of respecting environment and nature in all decisions and in all laws. Yeah, I think I will end there and leave the floor to Ida.
Okay. As commentator for today, we have Ida. Ida is a lawyer, environmental activist working for system transformation for Earth system justice in the planetary emergency. She is the spokesperson and legal and scientific coordination at Aurora, a youth-led organization suing the Swedish state for insufficient climate measures. She is also coordinator of counseling and advocacy at Sweden's Environmental Associations of Law and organizations of young lawyers and law students offering free legal counseling to environmental initiatives and using law as a tool for Earth system justice. The floor is yours.
Thank you. Thanks for that, and thanks for organizing this and for inviting me and for lots of lovely presentations. Thanks so much. Just to give a quick explanation of the perspective with which I entered this room and listened to all of these talks, is that I'm part of, as has already been mentioned, a youth-led Earth System Justice organization who are suing the Swedish state for insufficient climate action. And the thing that we want to achieve by doing this is transformative change of Swedish climate policy adapted to the reality of the planetary emergency. So we're a youth-led initiative active in the planetary emergency, and we are hearing IPCC and IPBES saying that transformation of our economic, political, social, cultural, and legal systems will be necessary to avoid a planetary collapse. So we need paradigm shifts from exploitation to empathy and respect for broader subjects of justice than just humans. This has already been said lots of times today. But in this transformative effort, in this transformation of everything that needs to happen, we both need to tear down destructive systems and build up new sustainable ones. So as a strategic litigation organization, we are using the current system of law and acting within that system and using it for the causes that we want to achieve. And as such an organization, we find that it's an issue of legitimacy and credibility to also acknowledge that that system of law has flaws. That system of law has not been sufficient in preventing planetary emergency. So for our legitimacy and credibility, we also want to work for transformation of the legal system and alternative ways to organize this very crucial DNA of society, normative skeleton of society. So rights of nature and other ecocentric and ecological jurisprudence models has been one of the main ideas or inspirations that we see as an alternative way to organize the legal system. And if rights of nature or other ecological jurisprudence was recognized within the Swedish legal order, then that would be so useful in our case, in our climate case. Because what we're doing now is we're arguing that we're sort of squeezing in protection of ecosystems and for the living world into our very anthropocentric argumentation. So we have a roundabout way of saying that the Swedish state has an obligation to protect forests and wetlands and oceans because they need to protect the climate, because they need to protect our human rights. And if there were rights of nature, then that path could be way straightened. So we could argue that other more than human subjects have the same rights as we do, and argue based on all of our rights at the same time. So apart from this very much facilitation of our argumentation, rights of nature or ecological jurisprudence could also contribute to these larger cultural paradigm shifts and transformations that are necessary, as has already been spoken about. So this very positive view is the perspective with which I listened to this. And with that said, I have one comment for each of the speakers, and I'm starting with Craig because you spoke first. And you talked a lot about how thank you for a very interesting presentation, first of all. And you mentioned lots of very interesting adoptions of ecological jurisprudence, so different provisions in different types of laws being specifically about nature. And I want to talk about a bit what Britta already mentioned, how we need to incorporate these thoughts, these ecocentric thoughts and relational thoughts into all areas of law, into the entire legal system. So how can all areas of law be transformed to incorporate ecocentric and relational and systems-based paradigms? And what initiatives are there that works for the incorporation of this into the other areas of law than just, or then specifically focusing on nature? And for example, transforming business law and administrative law and financial law and all the laws governing the activities that are driving planetary emergencies. So that's a question for you. And also even human rights law, like the right to property and the right to ownership of nature. Are there initiatives focusing on transforming that? And yeah, exactly, using ecological jurisprudence to replace exploitative legal structures, sort of. Yes, and then for Jaffa, thank you also for a very interesting presentation. And you talked a lot about how Europe is ready for rights of nature. And based on that, I want to talk about critique of the rights of nature concept, because there are lots of critical views saying that rights of nature has a very individual rights, Western property law paradigm that it's built on, and that is by far not the only form of ecological jurisprudence. We have way more relational, more multi-species care and relationships underlining, built on indigenous philosophies, forms of ecological jurisprudence. And I want to ask you, is Europe ready for that too? Or would that be a paradigm shift? And is Europe only ready for individual rights-based approaches to ecological jurisprudence? Okay, and then Jonas, thank you so much too for your interesting presentation. You talked a lot about how rights of nature is not a panacea, which I totally agree with, nothing is. And you also talked about how there are at least traces of effective regulation within existing environmental law. And based on that, I want to talk about how effective environmental law actually is. Because, well, the planetary emergency, I think, makes it obvious that environmental law has failed. And that includes, of course, the participatory elements, very important participatory elements of environmental law. So since this has failed in avoiding a planetary emergency, if environmental law was effective, why are we here? And do our legal systems not need to transform together with economic, political, social, and cultural systems? Because we know that these systems need to transform. Why not also our legal system? And if you recognize that the legal system does need to transform, then what other transformative pathways or legal solutions do you see? Is it mainly just more participatory rights, as Britta already mentioned, like evolve or building on these existing tools, or how can we transform it? Sort of along the basis of, if you criticize one transformative solution, what other ideas do you have? And then another final question in systemic environmental litigation, that like the case that I'm bringing, we're trying to make transformative change happen. And we have not been able to identify any provisions within environmental law that could lead to transformative change in our argumentation. So that's why we're focusing on human rights law, because that is sort of what we think, based on existing climate litigation, could lead to transformative changes of a state's climate policy, because that's what's necessary in order to protect human rights. But how would you suggest that we argue based on current environmental law? And not in this case in particular, but are there environmental law positions that exist that could create obligations of transformative change, or do we need more? Thank you.
Can I invite our three speakers here to sit at the front, and then we can, we can spend maybe the next, well, we have 1 hour, but maybe we can, as that's the maximum one, but we'll see if we can wrap up earlier than that. But we can spend some time here to talk about, I guess, a lot of questions here that you have to each other, but also questions posed by our commentators here. So just to summarize, and also I'll just like adding a little bit of my questions here that sort of like flowing through all of your three comments. So Pela was mentioning about this necessity for respect to other well-being, and then in the age of Anthropocene, this is something that we really are lacking of. And then I really like borrowing your phrase, Pela, this need to address fundamental misunderstanding, because it's kind of like, I guess, an accusation, but also something that has some truth to it, that there is a misunderstanding between different groups of people, but also between different living beings. For example, how we sort of misunderstand the value of nature in our life, and we treat them for certain things. So I guess like this idea of fostering a new relationship between human and the living worlds also need to address this kind of like misunderstanding, a fundamental misunderstanding. And Brita, you were talking about your positions regarding rights of nature, and that, you know, you recognize a lot of solutions is already in the system. And then, though we do not need to necessarily have rights for nature, but also you recognize some of the value in that as well. And you surface the question, what is actually necessary for us to address a lot of these environmental, ecological problems that we have right now, using the provisions that we have in law system. And Ida, you pose a lot of questions, but I guess the thread that sort of flow through all of your questions is this need for transformative changes across all systems, and that for people who are working in the legal system and using legal tools, how do we use what is available for us right now, and how can we search for transformative, how we can enact transformative changes using what is available in legal tools. So yeah, I mean, I can break down on your question to each of our speakers here, but I'm just gonna start with throwing it very broadly to our speakers who wants to take a first stab to any of the questions or the comments posed by our commentators today.
Well, there was a lot on, you know, whether this is a paradigm shift, and I've argued that, or that we would need a paradigm shift. And I think that, I mean, that the values are there. I mean, the people, that sort of survey after survey has shown that people value nature. And as Craig was saying to me earlier, that, I mean, no matter how conservative you are, you don't want to live next to a dump or, you know, environmental damage. So I think basically everyone would like to live in a clean environment, and basically everyone would like there to be environmental protection. And in these surveys, most people say that rights of nature is one way that they could consider achieving that. So, I mean, I think that the cultural shift, or cultural thinking, is there. And I think that this is hopeful news on our theme, because changing culture is really hard and changing law is relatively easy. and that law is a way of solving sort of collective action problems, and that it's one way that many people consider would be the right way, a right way to solve this collective action problem through harder environmental laws in general and specifically rights of nature.
Yeah, I guess I'd like to make a comment that I think connects a number of different threads that have been made here. I mean, I would fundamentally agree with Jonas that, I mean, there are other legal models that could work if enforced, right? And as I think Pella said, rather, the problem has been a lack of political will to actually enforce them. And the same, frankly, can be true for rights of nature laws, right? So the problem is not a lack of legal tools that we can write down that, if fully enforced, would probably address the problem. The problem is the lack of a political will so far, primarily to enforce them, regardless of the model, right? Whether it's, and so then the question becomes, like, how do we change that? And that's why the change in the value model, the values or the normative assumptions about what is appropriate behavior and what is not appropriate behavior is so important, because you need that to mobilize the political pressure to get politicians to enforce the tools, right? And so, I mean, for this reason, you know, I often get asked, you know, in the U.S. context, whether I think the rights of nature movement has been successful or not in the United States. And I say, well, it depends what you mean by success. You know, if by that, you know, if what you care about is, can we get a court, can we use rights of nature to get a court to force a politician to do something they don't want to do? No, that's not, hasn't happened so far in the US, and I don't think it will ever happen. And for that reason, I think climate litigation is important. It's probably a better tool in the US and many other places if your goal is to, in the short term, try to get a court to force someone, a corporation, to stop doing something, right? But, you know, like, to get the political will, ultimately, we're going to have to change these normative paradigms. And I think rights of nature and other ecological approaches, even framed responsibility, you know, so I agree. Like, rights and responsibilities are two sides of the same coin, which is why they get all lumped in this common I came up with the ecological jurisprudence concept to try to say, yes, these are two sides of the same coin. Everybody's rowing in the same direction, I believe, but it matters how you frame it.
I'd like to respond, I get to your comments about the U.S. And the success of rights of nature laws, and I agree that the laws that have been enacted in the U.S. have been successful in getting attention to an issue, and they have not been successful in getting courts to go along with them. Yeah. But the reason, I mean, part of the reason at least, is that those laws were designed to fail, I think. They were designed to get attention, to get, and they were... Sure. In my view, drafted in a way that, I mean, that was intentionally unconstitutional. They not only said these natural communities have rights, but corporations don't have rights, and we're going to ignore state and federal law. That
it's based on the legal personhood model. So again, it matters how you structure rights of nature. They're not all equal.
But I mean,
as you say.
They do. But it was a choice to cause conflict and get attention.
For sure.
And
it's been fairly successful.
That's been very successful at that. But I think that better laws are possible, as you know, that or have also written about. The Santa Monica law was not written to fail, and it has worked better than those laws.
I would like to just before I go.
No, well, first I should say that I also think the comments are useful, and I would like to come back to some of them, not least the point about law and transformation, which I think triggers a lot of thinking. But I wanted to just to reflect on what Jeff said here, and also it was part of your presentation about these interviews, the studies, to see what people answer and what that means. I think, well, it says something, but it also shows, I think, how complex we are, and we want a lot of things that are not compatible. I think in this room, even, I mean, even if we have these strong ideas about rights to nature, we will need to use them in one way or the other. I've done this test with students, and I can do it here. I don't think how many here has a telephone mobile which is older than 5 years. This is actually maybe good. I've never seen, maybe one, it was about 20-25% now roughly who has. 20% of the population has a telephone. But I think the we want our phones, we need to have them. There is a big discussion in Sweden about areas close to our second biggest lake, Vättern, whether and other parts of Sweden also, to exploit certain rare minerals and to use them. There's a strong opposition. They should be used partly for mobiles. Today we import these metals from China, from Congo, from Russia, or elsewhere. I mean, we need to deal with these things. So I mean, it's fine to say, yes, I'm in favor of this and that, but am I prepared to give this up? And at the end of the day, this is something we have to deal with. And just a short related point that we can come back to. When we discuss these things, we have a society when a lot of people are not, and I see that today, youth of today, someone was told, an anthropologist in Uppsala say, we may think that the youth of this is generation Greta, she said, that is what we would like to think. But she said, no, actually it's more of a generation Bianca. I'm only quoting her, I would never say that myself, but we have different ideas and not everyone is on board. And if I would like to improve protection, I think the way we discuss it, I'm not against the idea. I think we can construe things as rights. But if I were to push rhetorically and strategically for stronger protection of Natura 2000 area or something, I don't think that the best idea would be to push that they should have rights. I think one could achieve similar ideas without pushing it so much, knowing that there is today a concern that there is a reaction the other way, that there are a lot of strong activists who think we should reduce the protection of the environment, who want to cut down the Aarhus Convention rights and other things. So there are so many aspects to take into account here when we argue these things.
Yeah. I was just wondering, like, just going back again to your response to one another, because we talked about this idea of rights of nature to respond to anthropocentrisms, right? Like to address this kind of like the ways that we see our relations with the nature and the living world. And also we hear about your argument about there are real problems that need some of like the current legal provisions that we have now that may not be in that direction. So my question is, perhaps from someone who is not nor political scientist nor legal scholar, are those two mutually exclusive, and in what way do you like need to hold on to one without abandoning the other? Or is there, kind of is there like a really divergence between these two? Well, I'm not opposing view, but like two different paths that you are proposing here.
Between a protection regime and a rights-based regime?
I'm not sure, like the actual.
I don't think anyone wants to give up the protection regime, and I don't think that they're in conflict.
I mean, any of you who wants to.
No, I don't think so. And again, as I was starting my point, I think that this discussion about rights to nature is valuable to be more in a more profound way of thinking that about anthropocentrism in relation to others. But it's my concerns is more that I think that the potential to protect something by using that is sometimes exaggerated. But I think that, well, again, in different countries, in different ways may be more effective than others. So I don't see that it's we have to take one or the other approach.
Can I make this?
Yeah.
So I think it's important to remember, because discussion of law can always become abstract, right? So I think it's always important to remember we are human beings trying to figure out how we can manage human beings' behaviors in a world such that we don't create a world where we unnecessarily create suffering, right? So, I mean, I think it's important to remember there is a human interest in this, right? And so, again, so what is important, this is why I differ between the jurisprudence, the legal theory understanding, and whatever legal tool that you craft to try to reflect that. And the underlying change that I think needs to happen is this shift from thinking that human beings are the only entities that have moral value, and this is where rights come from. Like, so in some societies we indicate what has moral value by giving them rights, and others you indicate by having obligations towards them, and that's fine. Either one's fine, right? In a world where the world is constructed, it's assumed that all the component parts of the world are independent, right? Like, so the analogy is like a machine that has different component parts, and humans are capable of taking them apart and rearranging them and manipulating them and creating things and bending nature to our will. And I think there's a growing recognition that that assumption has been exacerbating environmental crises that we're now struggling to deal with. And to deal with them capably, we need to transform the legal system to recognize that the natural world is better understood as nested systems of which we are a part, right? And so this is where, and so again, the focus, we have to always come back to this, the challenge is creating rule systems that allow human beings to manage our own behaviors such that we don't overwhelm the carrying capacity of Earth system, planetary systems, Earth systems, ecosystems, however you want to think about the systems. There are, natural generative cycles that if we can keep them that produce the conditions of life, we need to keep those going, right? And so it's not, and so the shift has to be going from this rule system that assumes we humans can manage the land, we can manipulate nature, bend it to our will, solve our problems that way, to recognizing that our task is we need to manage human behaviors so that we exist within the carrying capacity of these systems, that we don't overwhelm them and cause them to collapse.
And I sort of as a response to both, I think that, as you point out, everybody wants a good environment. Everybody wants, for the Earth systems not to collapse, but we also want our cell phones. But I think that, law is solving a collective action problem that most people would, even if they want the cell phone, maybe they also want a law that would prevent them from buying the cheapest meat or the cheapest cell phone if everybody had to do it, so they would feel that they would get the benefit of limiting themselves. I think that is a great demand for stronger environmental laws because maybe people don't want to make a personal sacrifice, but if they know everyone else is doing it, then they want to do it.
No, I think I fully agree, and I think one has to keep in mind that law, in that sense, serves so many functions, and I think it's really important to have in mind the need to have the law in our behavior to take in what to encounter, not take for granted, not use resources as if it was only for mankind. But again, what comes to mind, and it also goes back a little bit to the points here before. First of all, I think we have to keep in mind for law to be effective and legitimate, it should somehow reflect the will of the lawmakers, so to say. We have this classical idea about the tension between positive law and a kind of law of nature, a bit in what I was thinking about, what Pelle was speaking about. This is really a classical idea. Is there a law which is outside the scope of humans? But I think it is important to have a solid support for the legislation, and the only thing to have changes is to have this kind of development to argue that we need to change, either outside we change the law from the outside, but I think there are also some elements, and I will come back to that within existing system, how to do things. But for instance, one of the, I think, positive experience of the climate change lawsuits around the world, the thousands that we have, and for sure there are those who are furious about them, and they argue that this is just a way to circumvent, to avoid democratic rules. We go to court to try to legislate in court. And I say, no, look, court procedures are part of the transformation, and it shows, and I think this is important, that we should have a transformation through the rule of law. I don't believe, and there are those in all communities, but also in the green activism group who have some idea about a green despot, or that you have an enlightened despot leader who shows with the full hand, and I don't think there is no enlightened despot. They are just despot. They are not to trust, and I think we need to point out that the transformation has to be made through the rule of law with a certain degree of predictability, with trust that comes with law, and maintain it in a democratic system. And I think this also, links back to what the law can achieve. Law should not, I think, transform society overnight. Law is not revolutionary in itself. If we take the Swedish case, and I think this comes back to our climate, the pending case. Sweden has signed up to the Paris Agreement, to the European Convention on Human Rights. We have a Climate Act. We have a constitutional provisions that the public administration is responsible for sustainable development. Then all of a sudden we have a political shift. We had a rather broad consensus about climate change politics. And then we have a political shift. And now all of a sudden we have much more of climate, if not denial, skepticism in the parliament and so on. And I think it's important that those laws that were adopted, they should still apply until these laws are changed. They should not depend on shifting political shifts, short-term shifts in the parliament. And I think law is what I think some of resilience researchers would call a slow driver. It is not something that changes overnight. And I think one has to have that in mind when you, if I may also expand a few minutes on the transformative possibilities. I think law can transform, but it will not do it overnight in a revolutionary way, step by step. And I think, again, the climate change lawsuits are one example, actually, of a little step in that transformation. It's a completely new thing that states could be held to account for something so complex. And it shapes our minds. Media loves climate change lawsuits because all of a sudden they can make climate change explainable for their readers, that there are some who are responsible and there are some who are suffering. I think this is a little example of that. Another point is to expand our laws across state borders in a broader way than we have done before. You asked for a transformative solution. I think focusing on corporate responsibility is a very important element here. There has been traditionally ideas about corporations, again, being persons. They are only responsible for themselves. The parent company is not responsible for the subsidiary, just like I'm not responsible, well, only to a limited extent to what my son and daughter does. Now we see a different approach to this. Corporate groups have responsibility within the groups, but also throughout the value chain. The recent EU legislation about corporate due diligence, I think, is a very important step to internationalize this way of thinking. Before, it has been very much up to each state, whether you can sue a company under the Alien Tort Claims Act in the US, by the way, an old act from the 18th century, or you can go to the Netherlands or some countries. In other countries, you can't. Now we see that the UN guidelines on business and human rights, the EU legislation, all of a sudden, it changed the understanding. I was speaking the other day at a law firm, and they are very much aware that Swedish companies may be held responsible for what happens abroad in a way that they had not been before, because they think you can hide behind national jurisdiction and state borders. So there are, I can give you some more, but I think one has to look at law in that sense. They can transform, but it cannot and it should not change society overnight, because that's not what the law is there for.
Yeah, I mean, in Ecuador, which is probably the only example you can get to date, just because it's the only one that's been around long enough, where you see some transformation. It took a decade from the time you have the Constitution, and this was probably the strongest, most embodiment of these principles that you could have, right? And it took literally a decade for like the jurisprudence to get to a point where it started to become implemented in a way where you're having an effect. So it is a gradual. I mean, on one hand, a lot of lawyers will tell me 10 years is not a long time for a lifetime, yeah. But it's feels like a long time, right? And in the first 5 years, there were all kinds of studies that said Ecuador has no impact because nothing got seen fit.
Yeah.
It takes a long time.
One thing you study is sort of that big groundwork that comes before the laws, the shifts that come before the laws are enacted.
I actually want to pose a questions about that. So from these so-called landmark cases in rights of nature or ecological jurisprudence, is there any of the cases that you can shed a little bit more lights on that could indicate that there's a transformative changes happening in different systems?
Well, I mean, another case where I think each case is unique, right? But another case where you are seeing actual change on the ground, again, because of the unique pathway and structure that happened, would be the case of Te Urewera in New Zealand. And, you know, I don't want to, it would take a long time to sort of describe the entire situation there, but essentially this is a story where you have a Maori tribe that was engaged in a treaty negotiation to get restoration of their traditional homeland, which had been converted to this beloved national park. And long story short, they get this treaty agreement, and Teotihuacán, which is the name of this forest that was a national park, gets delisted from the national park as part of this transformation. There was a breakdown in the negotiation between the Crown government and the Maori iwi, the Tuhoi, over this issue of property, right? Because from the Crown government's perspective, they're thinking of this as who owns this land, who has property on it, and it was just sort of culturally and politically impossible for the government to say we are transferring ownership of this beloved national park back to the Maori. The breakthrough, the breakthrough came when the chief Crown negotiator realized that the Maori, the Tuhoi, don't actually care whose name is on some piece of paper in Auckland on some title deed or something like that, because they don't think of this as an ownership relationship. They think of it as a kinship ties, and they want the restoration of their ability to restore traditional, customary practices and restore their relationship to the land and traditional governance practices and so forth and so on. And so this was it occurred to the chief Crown negotiator that you could adopt this concept of legal personhood, because if we can declare the forest, its own person, then it can own itself. And then the Crown government can say, hey, we're not giving it to the Maori, and the Maori can say the Crown government. But then the really important thing is who is the guardian, right? Who represents it? And so then they created a guardian body it was 9 people, but it was essentially dominated by the Tuhoi. And so in effect, they transferred the territory to the Tuhoi. An important part of that then is, I want to emphasize, the ecological jurisprudence in that particular case did not come from the legal personhood provision. Many Tuhoi were not in favor of this whole legal personhood rights. They could care less. They don't like the rights-based framing. But as part of the treaty settlement, the Tuhoi lawyers made sure that they embedded in the resulting Act of Parliament a whole bunch of provisions that essentially establish Tuhoi's understanding of the human-nature relationship. And that's where the ecological jurisprudence comes from. And then they appoint so they told me what the legal personhood did was it blocked the pre-existing overriding sort of regulatory structure that existed and created the space for them to create a new governance arrangement that fits the criteria of our ecological jurisprudence, right? It's a systems approach based on a relational ontology rooted in Maori traditional ecological knowledge. And then they created a structure this guardian structure that was controlled by the Tuhoi. And then it was explicitly said they were responsible for creating a new management plan, because the Department of Conservation no longer applies and no longer has the authority. And so the Tuhoi created a new management plan that was rooted in Tuhoi understandings of the human-nature relationship, and they called it Managing People for the Benefit of the Land. And it was a conscious dig, if you will, at the conservation department, because the conservation motto is, we manage the land for the greatest number of people over the greatest number of years, right? And they purposely flipped it on its head and said, no, we're following a fundamentally different normative paradigm. That is, we're managing human behaviors, because that's all we can do. We can't control the land or nature, and you're naive and arrogant if you think you can. But we are going to manage human behaviors for the benefit of the land, by which they mean just have an ecosystem where you have balance in it, right? And the component parts live equitably. So it doesn't mean that you don't impact the land, that you don't have any negative, that humans don't do any damage. There's an assumption that humans are part of nature. You're going to impact the land. We're going to do some damage. That's not inherently bad, necessarily, so long as you do it within limits, right? So that's, I guess, and that's in practice because of the law, what the legal personhood thing did was create space for this new alternative me using my Western terminology, call it ecological jurisprudence, they don't necessarily think of those terms. But the overlap in these concepts is the systems relational approach.
That's interesting. I just want to get back to Ida's, related to that, Ida's question to Jonas. In systemic environmental litigation, there is what she claims that there is not yet a provision for transformative changes. And then, I mean, in comparison of some of the things that are happening in ecological jurisprudence in enacting such changes, what do you think would be like the most potential?
What comes to my mind, the closest, is not dramatic in the way that you can see change in the landscape and the protection from one day to the other, but hopefully a slow way of chain thinking is the concept of an ecosystem approach, which is today also part of the law in Europe. And now you can find it in the legislation, but it was, I think, if I'm not mistaken, originally it was a new way of applying existing laws, introducing a way of applying them in a more adequate way. I think you may say that this, again, if you speak of transformation as a bit of step-by-step part of this, could have a slightly similar potential as to what you described in New Zealand, that it puts the ecosystem first, to say that, and I think the understanding of resilience and that it's not a matter of the Earth's carrying capacity. It's not a linear thing that we can pollute to this extent and then it's fine. It's to understand how all this understanding of how ecosystem functions should come into the legal system. One thing that came to mind when we were referring to climate change is that I have seen that there is a discussion on whether we will see a parallel development of lawsuits on biodiversity as we have seen on climate change to hold states to account. And I think it could be a good way again to define and hold states to account and remind not only states, corporations as well, and by going to court. And I think it's a good way to show again the rule of law. Having said that, I think one should also caution a bit to expect too much of the court, and also, even though I don't think that it means that we put all the legislation to the court by going there, there are of course examples of courts where it doesn't work well. And as myself, I'm quite happy that we don't have a court in Sweden that can decide whether abortion is illegal or not, or decides on what. I think we'll have to keep in mind that some issues should be dealt with by the legislative body or in other ways. But again, to hold states or corporations to account, I think it's a good example. And again, the expanded rights, participatory rights that we have seen only in the last 30 years, we may think that it's a very long time, but it is actually not. And before that, it was not a part of international law. That, I think, is a very promising step, but we should keep in mind that that development doesn't necessarily have to go in the right direction in the future. There may be clashes, and it may go in the other way. We can see groups in this country who would like to limits the rights for environmental association, for instance, to appeal cases. So it's not that this is a given direction. One has to fight and to insist and invoke and use these rights.
Anyone wants to respond to that?
I guess I would. Or I don't know, I don't disagree. I guess that there's a lot of different things in the law that could be used, and that there's also a critique that was raised by Ida of rights of nature from sort of a more as not going nearly far enough or being too much like the laws that we have now. I guess I would maybe I'll take the opportunity to respond to that.
Yeah, sure.
That point. You asked, do I think that Europe is ready? Or if I think though I think Europe is ready for rights of nature, do I think it's ready for ecological law? I suppose, and I've argued that rights of nature doesn't have to be radical. I mean, there could be a system for incorporating an ecosystem in the way that a corporation is incorporated, and it would basically be the same sort of entity as a corporation. I think this could still be desirable if it would make it possible for the ecosystem's interests to be weighed on the same level as the corporation's interests, or be a way that just force both people and the legal system to think of those rights of the ecosystem as being on par with the corporation's rights. And as you say, there's a much more radical, I guess, type of rights of nature that's also proposed, or something outside the rights framework, but more of a relational framework. And I think that the values are there. I don't know. I think that change takes time. I agree on that. And I think we're only at rights of nature laws are, this first conception is less than 20 years old, and a lot has happened in 20 years. And there seems, as Craig's presentation demonstrated, there's a big acceleration. So I think a non-radical rights of nature possible. I think possibly a more radical rights of nature may follow from a non-radical rights of nature, but I think it doesn't necessarily need that sort of non-radical rights of nature. Yeah, I don't know, but I think I do think that the values are there, but that the structures may take time to change.
From what I get, is like there are points of agreement and disagreement, of course, but I guess the overarching, the common opinion, or common agreement across all of these different legal professions and tools and alternatives is that different things work at different contexts and different times whenever it's necessary, right? And then I personally, while hearing all of you here, well, what I see here is there is a need for more synergy between these different things that are happening at different times. I don't know if you agree, but then my question, if I can pose a question here, and also related to our previous commenters here, what would be needed, what is necessary for different practitioners and people working in these different spaces to build this synergy and to realize this kind of transformative changes that may be slowly be working on at different aspects. Yeah, I don't know if that's.
I guess I have an answer, but it may sound sort of, I guess, basic. One of the main reasons that I created the Eco-Jurisprudence Monitor was because I had been working sort of in this arena, just sort of observing different movements, doing different things, and it struck me that there were essentially unhelpful, I won't say unnecessary because I think there were good legitimate reasons for debates, but like there were conflicts between people that, from my observation, I was like, you guys are on the same side. Why are you getting bogged down in conflicts over is rights of nature better or ecocide better, right? Like it's not, in my opinion, sort of a particularly helpful debate. Or is animal rights better or rights of nature better? Which one's worse? Which one's right? Which one's wrong? Like, so forth and so on. I don't think that those are, it's not that there isn't like understandable, legitimate differences, but there's so many more areas of overlap and agreement than there are, and the nature, in my opinion, the nature of systems change, the way systems transform is you need to have lots of people pushing in the same direction simultaneously at all different kinds of policy arenas at multiple levels and scales simultaneously until you get a tipping point and you get momentum towards the transformation. And there's enough space for everybody to fight their fight in their particular place at the same time. We need everybody doing it all at the same time. We need youth doing climate litigation at the same time as people pushing for ecocide laws, at the same time as communities in Africa pushing for protecting sacred natural sites, Yeah,
I think that for the people who are working for change, it may seem like nothing is happening, and for the people who are just reading in the paper, it seems like the law is changing overnight. But I think that, as you say, there's a long push often before we see a change in the law, and then the law also can, even when there's a legal change, it's that's the start of something. It's not the end of something.
You asked what needs to be done or how can things be improved. And I think if we're speaking about a way of thinking of law and also actually how we teach law, I think your point is very important to understand that almost every legal issue context appears at different levels or involve different levels scaled at the same time. This idea, being in this group of scholars linked to Resilience Center about planetary boundaries, is very useful, I think, to understand that the local is part of the global. And climate change is really a good example of that. When Switzerland, in the Klimaseniorini case in the European Court of Human Rights, or when the Dutch government in the Urgenda case, and when Swedish politicians, for that matter, say, we don't need to do anything in our countries, we don't even represent 1% of the emissions of CO2, of greenhouse gases. Even if we stop tomorrow, nothing would happen. Why are you dealing with Switzerland, with Netherlands, with Sweden? Look at China, the US. Fortunately, the courts have reacted to that, say, no, you can't argue that way. Every state has to do its reasonable share. And I think this is a fundamental point. See, we are part, this what you do locally. It's true, if Sweden would cut down all greenhouse gas emissions tomorrow, no one would really observe any specific change. But that applies to probably 80 to 100 countries in the world. Each one stands for a little bit. And if all countries would say the same, we will not achieve anything. So I think that is a good example to say you have to do something, even if you may not see the direct effect, because you're part of a greater context. The same, that applies, I think you could do it parallel to biodiversity. You could start thinking about that. When corporations act across state borders, in terms of, I took the case of rare metals. We have to think of that. When we discuss whether we are going to extract minerals in Sweden or not, we have to take into account, well, if we don't, where will we get them from, as long as we need them? Waste issue is a similar thing. Waste has been shipped away in industrial countries to get rid of things. Either what they're called waste or they're called something byproduct or whatever. I mean, these are legal fictions, but I mean, these things have to be taken into account. What we do here has an impact elsewhere. And today, even in our law program, understanding the law in a greater context is the way we teach today is very different from when I was a law student, when we had very little about the transboundary dimensions. Now, not only in environmental law, but in copyright law, in the rights of the child, on a number of issues, criminal law, students are better prepared to think in transboundary terms, I would say, than students of my generation.
I was about to ask, that's an interesting perspective, and I just get follow-up questions from that. When you see like it's important, as one of the most important thing is also how we teach law, and it's also about taking this transformative and holistic view of everything, but also from growing from our previous discussion is also taking into account that a lot of these different processes have their own roles in enacting changes. But also I could realize that not everyone are aware of this, that this process takes time, and different processes have their own use and have their own context. So what would be more useful for like teaching laws, but also teaching our generations right now? I mean, like not necessarily our and younger, but also like all generations right now, in how we enact change, especially in laws perhaps, but also in political science, because you're a political scientist. How do we take a step closer towards this, a more holistic view towards more transformative changes? The specific thing that we need to... I think
in environmental law, there's actually been a lot of change already towards how environmental law is taught. 20 years ago, it would have been called natural resources law or maybe property law. And that was a perspective on what is this thing that we're studying. We're studying how can we exploit natural resources, I guess. And then there's a move toward calling it environmental law. And then even though it's the same category of law, maybe we're thinking of it from more of a perspective of how do we limit what human activities do to the environment. And now there's a push to talk about ecological law and not so much about the balance between humans and nature and how the law is going to balance those interests, but rather how the law is going to integrate those interests. And I think has started to trickle its way into the educational system.
Any more things to add?
Okay. Well, again, we have an interesting. Well, first of all, as you say, I think it's important that those who deal with teaching in law or who work academics in law, not least in environmental law, that we also work in transdisciplinary communities and groups. I think that is really a good case. This seminar shows that how useful it is, not only to look at law from an internal perspective on how to interpret and how to apply and to explain what the law is, but also to look at it in relation to the consequences elsewhere. And I think in that respect, it's very good too. As a teacher, if you engage with students, quite often the students come up with good, fresh ideas that you hadn't thought of. So it could be a two-way street. We have an interesting case now. I'm not saying that it will work or change the world, but I think it's rather unique at Stockholm University, where we struggle. It's presented as a program, and all topics, if you do property law, if you do constitutional law, if you do history of law, everyone wants his or her subject to be part of the program. And a couple of years ago, I was struggling to have a mandatory course in environmental law, and part of that competition is what's agreed that instead of having a specific basic course in environmental law, there should be an environmental law streak, it's called, reflected in all the courses. And only now in the last couple of years have we started to do that. So actually, the idea is that, and we are working on it right now, that all mandatory courses in the law program, whether it's about European community law, taxation law, history of law, law and informatics, they have to address something that has to do with environment protection, environmental law. So when they study law and history, they are looking at the case in Roman law dealing with a pollution issue. When they do taxation law, they look at certain what's called point taxes. You use taxes as an incentive. I think this is a little an attempt. I'm not saying that it will change everything, but even those who do not care, who don't want to do any career on environmental law, they want to go into big law firms to do commercial transactions. They should have, as part of their knowledge when they get the certificate, they should have come across, they should have struggled with these issues. Whether they thought it was fun or boring, I don't care, but they should have that before they can have a certificate as a lawyer.
I think we also, in Uppsala, we see that in the research sphere, the people who are in other areas of law are doing environmental tax or environmental legal history or business. And maybe it comes from being exposed to it as a student in those courses. Environment is now thought of as an interesting or worthwhile aspect of many other areas of law.
Thank you for that. I think we have about 5 minutes now to wrap up. I will just ask for you do you have anything else to address for any of your commentators here? Because you were responding to each of their questions, but I was wondering if there's a specific things that have not been addressed yet.
No, there may be.
Oh, yeah, sure, yes. Thank you for. My mind is all over the place.
There may be some other who want to challenge if time permits.
Yes, that would be really great. Yeah. Is there any questions from our audience in the room today? Because you've been with us for quite some time.
Yeah, no, I think when we're increasingly talking when we design transformations that we have to sort of undesign or take away things. Is there anything inside the law system that you think of that needs to go away or be done differently? And that sort of, I would argue, slap suits in the US, for example. Maybe, but is there part of the system that you think has to go, that we have to let go of?
I don't know, but I think, ironically, that it would be easier to recognize rights for nature than to take away rights for corporate legal persons. And so maybe, I guess I would say that it should be easier to not treat corporations as human persons in some circumstances.
Yeah, I second that. I guess I could make one, I think it was Brita, right, who asked this really, I can't remember who asked it, or maybe it was Ida, asked this fairly complicated question about property rights, which we would need a whole other seminar on. So I'm not going to go into an actual, we can talk about that later. But I guess, you know, you're all lawyers, you know, there is no one property right? There's a bundle of rights and they vary from place to place and place. I don't think it's, so I often have students who have this conception of property rights are all either all good or all bad, and you either have them or you don't have them, and I don't think that's helpful. But rather just to understand that these are bundles of rights, right? But I think it might be helpful to get rid of this idea that you can destroy your, that property rights means you can destroy your environmental property. Or if environment, you know, some natural entity is, you know, we have to have sort of like use rights. Like there's always going to be some element of property to sort of figure out who can use what and how much and that sort of thing. But it's not obvious to me that we need to keep in the bundle of property rights the right to destroy an ecosystem just because you have a piece of paper that says you have title.
And actually that is the case in many, most, well, I can't say most, but in many jurisdictions, property rights do not allow you to do that. Mm-hmm. That is already in the case. You have that system here, you have it all through EU, I think in the US too. That means you're not allowed to kill the spotted owl just because it happened to be on your property. For instance, well, I was taking okay, showing my ignorance about US law. But I was going to point out something else about property rights that I think is very relevant here. And that is the idea that the property right is absolute. I think one has to get rid of that. You say as a bundle of rights. Property right serves a function of some predictability. And that I think it's a legitimate idea that what you own, you have protected. But it can't be, and I think this particular for the corporations is an important case, where corporations may think, for instance, if they get a permit to extract minerals or to carry out an activity, it has been the idea that that permit would be like a property and it lasts forever, and if all of a sudden the state stops, say, no, you can't continue, that they should be entitled to compensation for that. And I think we need to think, and this is very much in line with resilience thinking, that if you do an investment, you should know beforehand that you get certain protection, but you cannot expect to go on forever. If circumstances change, if the effects are either by the activity itself or in combination with others are worse than you thought when the permit was given, that activity may have to stop without you being compensated one nickel. I think that idea of understanding property rights are not eternal, they're not absolute. They serve a function, but they have to be balanced, they have to be reviewed, there has to be some flexibility, is something that I think is very important.
Anyone to add to that?
And in Sweden, it's actually a lot harder to regulate for the environment than in the US because there's, if you reduce the value of what a landowner can use with their property, then they have to receive compensation, which we don't really have in the U.S. To the same extent. So it actually can be, I think, pretty hard to have environmental regulations because of that, for that impact how a landowner protects their property.
Interesting. All right. Thanks for that. Other questions in the room? Yeah, we have two.
Yeah, I was just wondering what makes certain countries more advanced, or like Ecuador, you mentioned, and maybe New Zealand. Why are they in the forefront of?
Yeah, great questions.
That is a complicated question. I guess the short answer is for idiosyncratic reasons, a moment in time occurred when they went through a system where they were rewriting the Constitution at a time when the existing political system had lost all credibility, and you had the rise of a populist leader who came to power on a promise to just tear down the whole system and build a new one from scratch. I'm sort of oversimplifying, but to make a point. But part of his campaign promise was to abolish the Constitution, write a new Constitution, which he fulfilled his promise. And the nature of the political dynamics in Ecuador were such that to create a winning coalition, you need to include organized, mobilized indigenous parties. That was just sort of the component, which gave indigenous peoples who had been mobilizing for a decade a seat at the table, and a fairly influential seat at the table. And there were negotiations that happened among a variety of coalitions, who were essentially allied over their hatred of neoliberal economics, disagreed on a whole bunch of other stuff, but disagreed on dedicating the new constitution to getting rid of or rejecting a neoliberal approach to development and pursuing a political project that seeks an alternative rooted in this Andean indigenous concept of summa causa, which is very complex. And so I can't really explain it to you, but among other things is based on this notion of a relational ontology and systems approach. And that, as a result of negotiations, got expressed in terms of like how you would fulfill that aspiration they codified that as a set of three sets of rights, sort of like economic rights, social rights, and rights of nature. And it got in the Constitution. And then they had to figure out how to implement what that looks like in practice. And it sort of took over a decade to sort of evolve jurisprudence around that.
Each country has been unique.
Unique, yeah.
But in Latin America, there has been maybe more of a trend, partly, I think, because the situation has felt so desperate, and the courts and other actors have felt that nothing else has worked. Or do you share that?
No, I think that's entirely right, and a good example of that. So at this moment, it's not. I think it's important to note that at that moment in time, they had this very participatory. I think it matters that the process of designing the Constitution was a very participatory process, where all citizens were invited to submit proposals and then there were working groups that were created around the proposals submitted, and to prompt this discussion for citizens were given the question of envision the Ecuador you would want in the future. And then citizens sort of responded to that in different ways by making, and this was at a time when, Ecuador was an oil producing, I mean, it still is, but most of its GDP came from oil production and exports, but they are running out of oil. And it was understood that in about a decade, they would be out of oil. And there was this discussion among the Ecuadorian population of, do we really want to sacrifice our natural biodiversity and all of the other rich, resources that go along with that just to dig up that last drop of oil? Or should we take this opportunity to think about an alternative?
I think they also tried the alternative of asking everyone else to pay them not to.
Well, yeah, so they tried that. That was the origin of the Yasuni,
I think. Sorry. No, I was just saying when we speak about some countries being more successful than others, we should also keep in mind that legal systems are also quite complex. It's usually the case that some country could be perhaps more advanced in a certain area of the law. I mean, I know too little, but I would be surprised if Ecuador is ahead of all other neighboring countries in all respects. And I'm not so sure that they have a very effective enforcement system in other respects, although they have this constitutional notion. Mm-hmm. So I think one has to keep that in mind also when comparing. It's very complex to compare or to rank legal systems like that. You can find that there are certain elements that works very well in some countries than in others. Quite often, countries can have different approaches to dealing with some things, and they may come to rather similar solutions. And I think this is an interesting case. Ecuador may have found a way ahead that may work there, but maybe it doesn't work in Germany. And,
Well, interestingly, I mean, so Ecuador was first, and other Latin American nations perhaps were looking at that and saying, we'll try it too. And I think it's not a coincidence that Spain is the first European country, because you get a sort of a jurisprudence built up around an idea, and countries look at each other and try things that may be working somewhere. So one can see this sort of the movement of legal ideas, and sometimes they don't necessarily work if you're just transplanting something from one place to another. But I think that there can be trends also in types of legal systems. What types of legal systems?
Awesome. Just
You still wanted to do you want to go home?
no,
So
my
I'm
bad.
thinking a little bit about the scale. So you talk about protecting a forest or a wetland. Can you protect the tiger? Can you protect, like, can you give rights to the whole Baltic Sea? How would that work?
There have been different rights holders recognized in each, I guess, jurisdiction that recognizes them, and some of them are recognizing rights for nature as a whole. And then in Ecuador, when the court has, where nature or Pachamama, this living whole, who's the rights holder, but when the court decides each case, they're saying we're not creating a new legal person, but we're deciding how the rights of nature will apply in this forest or to this individual animal. So they have applied it even at that level of individual animals who have rights as part of nature. And I think different things this is another situation where different things could work in different legal contexts.
I think also I think it was like Jeffa pointed out before, it depends on how you construe things. When you say that a tiger has a right, what does that mean? Well, today there are restrictions, prohibitions about killing them, about trading in them, etc., etc. You may construe that as a right not to be traded in or whatever. It may sound a bit odd, but you can do so. But further than that, what does it mean? And if you were to give rights to the Baltic Sea, I mean, what does it mean today? The Baltic Sea regime, the international treaty and EU law and other laws have provisions to protect it. It doesn't work very well. But what would it add if you gave it right? Should someone represent the Baltic Sea? I heard a bit about that before. Then who would have that mandate, and who would explain what is the right? You can do, of course, research. You can show the problems with eutrophication, with loss of fish stocks, but what would it add, and how can you deal with that legally? I think it's more than tricky, I would say.
I guess. Yeah.
I think we had Rose.
Very quickly.
Yeah.
Thank you. So I have, and maybe my first question has been overtaken by the answer that Jonas just gave, but my first question was if the panel members today have thought about or come across in their research cases where having rights of nature really add no value. And I was thinking through an example of the Kenyan legal system, and I do so because I'm a national of Kenya and I have a level of familiarity with that system. How the country protects forests. So the minister has the power to gazette an area as a protected forest. And once it's gazetted as a protected forest, guardianship, a sort of guardianship, though the law doesn't use the word guardian, is passed to the Kenya Forest Services. And that the Kenyan Forest Service does the job that I think would be done by the type of trustees that are contemplated or included in some laws that have been developed to effectuate rights of nature. So that's the first part. Sorry, it has to be two parts. Then the other thing is that also circumstances where actually having rights of nature creates serious problems or may create serious problems and provide rogue governments an additional legal or rhetoric to violate rights. And I'm thinking in the context of indigenous people who tend to care for and occupy parts of nature that are likely, in my opinion, to be the subject of rights. And I'm thinking of cases in which the governments can give, say, rights of nature to a certain forest. And in that forest, indigenous people live there. And it has been the case that whenever such pronouncement is done, even when the rights of nature is not deployed for that purpose, then conservation by enclosure is brought in, and indigenous people have to be taken out, or they have to be pushed to a corner. And I'm thinking that when such a thing is couched in as powerful a language as the language of rights, then it may become very, very difficult for indigenous people and their allies to push back, because it may be easier when it's being done under the framework of regular environmental law. But when the government says, no, this is actually a right, we are doing this because this forest has a right, then it might cause more problems for indigenous people.
Great question. Such a shame that such great questions come at the very end. But I'm sorry, but just one of you perhaps to just.
I would like to respond to that because I get this all the time.
We can have a mingle later on, and you can discuss this. I would also love to.
So this is a common critique and fear that I've heard. I would say so I'll first say, any rule system can be weaponized and misused at any time. But what you're describing is illogical according to the eco-jurisprudence framework, because what you're doing is you're projecting a conservation logic onto a rights of nature framework which is opposed to that logic. So because the situation you're describing comes from real lived experience of a conservation approach where there's this assumption that humans are separate from nature, and therefore we need to protect nature from humans, which means we need to wall it off, get all the humans out so that they can't impact it, right? That's the rights of nature approach rejects that fundamental premise that humans are separate and apart from nature. So there is no assumption that humans are not going to impact the natural environment. Rather, though, it does set limits and requirements about the levels of impact that you can have. In practice, where rights of nature has been implemented, it has actually been served to strengthen indigenous rights because indigenous peoples are able to more credibly argue that their governance systems are better suited to managing human behaviors at a level that allows ecosystems to survive, as opposed to giving, guardianship or to some outside industry. So it's just, I'm not saying it couldn't happen, because sure, governments can sort of bastardize and manipulate and twist something, but what you're describing just violates the entire fundamental logic of rights of nature. And in practice, it hasn't happened.
Well, that was built on a case before the African Court of Human Rights, so that has indeed happened, that they were claiming that, although...
Not with the rights.
Not with the rights approach, but I mean, it could be also abused the way you put it. So one has to be aware of it.
I mean, humans can abuse anything, for sure.
Yeah. Great.
Okay.
I mean, it's not a very hopeful note to end on this great public seminar, but I would like to thank the three of you to be with us today, and also the audience. It has been a really enlightening and enriching 3 hours or so for this panel sessions, and I'm sure you're welcome to take some of this to tie some loose ends and some unfinished conversation in the mingle in the foyer. And thank you again. See you in the next seminar, hopefully.
Thank you.